Hi there, this is Samantha from the Law Offices of Samantha Wolfe, and today we're going to do a seminar on our first steps. So I wanted to focus on our first steps of things that we do in all different areas of law. So I'm glad that you could be on to join us. I'm going to go ahead and share my screen now so that we can get started. Okay, so we're located at 20 East 6th Street in Suite 206 in Waynesboro, and you can reach us at 717-655-2676. And we always offer consultations, so if at the end of this presentation you have additional questions, please know that if you call and we're scheduling something, it's a consultation. So with that being said, today we're going to get started on our presentation, and it's things your mama should have told you, first action steps. And the reason we wanted to do this is that Mother's Day is this weekend. And so whenever we think of first steps, we always think of a mom and a baby taking their first steps. So we had a client who reached out to us and said, could you do a virtual seminar that just went over the first couple of steps in all the different areas of law that we practice in? So this presentation is designed to help anybody who needs to know what are the first things that you should do when someone passes away for the estate administration or for the estate planning. We thought it would be good to be able to do that. So this presentation was a direct result of a client requesting it. So again, if anybody ever has a suggestion, we always welcome that. We're happy to do a presentation that way. Okay, so when I was preparing this presentation, oddly enough, I always try to listen to music when I'm doing something like this. It helps pass the time. So when I was going through my slides and kind of weeding out what we wanted to put in, I was listening to Leonard Skinner, and one of the songs that came on was Give Me Three Steps. And I thought it was very timely. So today we're going to channel our Leonard Skinner, and everything's going to be give me three steps. What are the first three steps that we can do? And so I'm kind of excited that we can do that. So I'll be calling back this slogan or this lyric as we go through the presentation. It offers a little bit of excitement. So let's start with some estate planning. So give me the first three steps. Give me three steps for estate planning. So let's talk about that. So the first one would be creating an asset list. So I know this actually isn't legal advice necessarily, but the first thing I would tell a client to do, and the first thing that we always try to do, is get an intake sheet to say, okay, when we're trying to figure out estate planning, we really need to know which assets we have, what assets, how are they titled, and if there are beneficiary designations. So if we're asking for, give me three steps of estate planning, things that your mom wouldn't have told you about estate planning, here they are. So create an asset list. We want a list of the accounts. Is it real estate, retirement, life insurance? We want to know, how is it titled? So is it titled in husband and wife's name? Is it titled in just husband's name? Is it titled in just wife's name? Is it titled with any children? So we actually have an intake sheet that when somebody calls in, we provide them that. And to the extent that they're willing to fill that out, it's very helpful when I'm meeting with them for their initial consultation to talk about their estate planning. The one thing I've realized is that I always try to start off every estate planning I see talking about what assets get distributed via the will, because I think there's this common misconception that all assets are distributed through the will. And especially when we're talking about husband and wife, there's this misconception that, we can have differences in the will. Not that you can't, but I was meeting with a couple the other week, and wife said, well, when I die I want this to happen, and husband said, well, when I die I want this to happen, and they weren't the same. And they were saying, in our will I want, or in my will I want this, and in her will she wants this. And I tried to explain, we actually have to bring those two ideas together, because especially if it's a married couple where they have joint assets, it's going to be the last one who passes away that's really going to govern if you have two separate wills that have different provisions. So it's about both of those wills making sure that husband and wife's goals get achieved. We also want to know, where is that asset held and what is the account number? So often the executor that a couple is going to name, whether it be a child or someone else, may not know what assets there are, where they're located, what the account number is. So having an intake form that we have at our office and can help provide the executor is always very helpful. The approximate value is also helpful. And some of that's just so that when we're talking about planning, if there are percentages or maybe they want a certain amount to go to charity and we're trying to figure that out using probate assets, assets that pass through the will, and non-probate assets, those with beneficiary designations or don't pass through the will, we need to know what values we're talking about so that we can help determine what the appropriate percentage is. We need to know beneficiary designations. And if we're working with a client to update beneficiary designations, we do recommend that they keep a copy of what they submitted to the company. I did have a situation where the client had submitted beneficiary forms and the company merged with another company, and the new company didn't have the designations on record. And so it was really helpful for the client to be able to say, no, this is when I signed it and submitted it, and these are who the beneficiaries were. We also like to know who's the financial advisor, their name and contact information. So we really value and want to collaborate. We really respect our financial advisors, and we want to make sure that it's a team approach so that if there is a financial advisor involved, we can follow up with them, whether it be a letter or a call to let them know this is what we're doing with the will and make sure there aren't any questions or concerns, or even if there's retirement beneficiary designations and we're going to recommend a certain designation, we want to make sure that the financial advisor is on board and that they don't have a different recommendation. So our financial advisors that we work with have such great relationships with their clients, and they really are our trusted advisors, and we value and respect that relationship. So we want to make sure that we're always including the financial advisor in any decision or discussion that we're having with the estate plan. The attorney information. So if there is an attorney involved, whether it be our office who's preparing the documents, or even if our client has a different attorney, we always recommend that they jot down that attorney's information and contact him so that they have it on an intake sheet. And then the accountant's information. So providing, the name, contact number, that's always very helpful as well. So again, it isn't necessarily the legal stuff that we're talking about right now. It's just give me the 3 steps that are most important. And I think knowing the assets and having this information in a readily available place and format is very helpful for the executor and those beneficiaries. So give me 3 steps. What step number 2 is checking those beneficiary designations. So yes, our job here is to make sure the estate planning, the legal documents are in order, but it is so important that we also ensure those beneficiary designations are updated. And so that's important for 3 reasons. And I want to bring this up because a lot of times there seems to be almost a negative or an adversarial relationship between advisors and the attorney. And I think that a lot of attorneys are actually not valuing or not appropriately responding in the way that we should. So the first reason that attorneys don't like beneficiary designations is because it does mean that their fees are capped. And so sometimes they'll not want an advisor or not recommend the advisor add a beneficiary designation. And so at our office, we are always going to encourage a beneficiary designation. And the reason for that is, number one, a DHS lien. So DHS is the Department of Human Services. There would be a lien if somebody was in a nursing home at the time of death and they were receiving Medicaid benefits. So maybe they qualified for whatever reason. What we want to make sure is that the beneficiary designations aren't the estate, because as soon as it pays into the estate, then it is subject to a Medicaid recovery lien. So we always like a beneficiary designation on there to avoid a DHS lien. We like it, number 2, to avoid probate. And this does mean that attorneys' fees should be lower in that sense. If it goes through probate, which means that the will kind of dictates how the assets are distributed, Pennsylvania has a chart that attorneys can charge, and it's usually a percentage based on the value of the assets. So a lot of times attorneys will say, we don't like there to be beneficiary designations They might say, they're concerned about liquidity issues, but I think there are ways around that. If there's liquidity concerns about how do you pay for the expenses for the real estate, all of that, we always want to have beneficiary designations on any accounts where we're able to do that. And then lastly, there's the whole will contest dynamic. So if you have a beneficiary designation, it doesn't go through the will. And so what that does is it helps to eliminate anybody contesting how the assets are being distributed. So when we're talking about give me 3 steps for estate planning, we have number 1, we need to know what assets, so creating the asset list. And then number 2, checking those beneficiary designations. And then our final step for estate planning is then doing the foundational documents. So please know that this is the third step, is really the attorney part of it. So I think step 1 and step 2 are just as important as this third step. So when we're talking about estate planning, that final starting point, we're looking at the first 3 things you should do. It would be making sure you have those great foundational documents for estate planning. So what do we consider are really important here? We call them our hot 5. So it's actually 4 different powers of attorneys, and clients are always a little bit surprised, I think, that we actually recommend 4 different powers of attorneys. I know that when we're meeting with clients, sometimes that may seem annoying that we have 4 separate documents, but the law has really changed so much in the last 5 years that it is so important that each client have each of these documents and that they actually are separate and individual. The financial, of course, we always recommend a durable power of attorney, which means it's effective when the principal, the person, so again, if I'm setting up my power of attorney, I'm the principal, and the person I appoint as the agent. So we always want to make sure that it's a durable power of attorney because it's effective when I sign it and when my agent signs it, acknowledging that they're willing to serve. If we have clients that are concerned about somebody using it before they want to, then we just don't have the agent sign it because they have to sign it in the presence of a notary in order for them to actually be able to use it. Then we have 3 related to the healthcare area. That's a healthcare power of attorney, a living will, and a mental health power of attorney. Healthcare power of attorney is if you can't express your wishes. Living will is you can't express your wishes and you have a terminal diagnosis. And then the mental health power of attorney is if you would ever get a diagnosis of dementia or Alzheimer's, what type of treatment do you want? And it allows your agent to consent to whatever treatment is needed. And then, of course, the last will and testament. So that we have, our powers of attorneys, which are the 4 different ones. And then the will makes up our 5th foundational document that we recommend clients to have. And again, this is the third part of the first 3 steps that you have to do for estate planning. And that would be making sure you have the 4 financial, healthcare, living will, mental health, and then the will in place. So these summaries are actually, we pulled these from our other virtual seminars. So to the extent that you want a very thorough explanation of powers of attorneys, the specific language that we recommend, and even examples of that, please check out our YouTube channel because we did a whole hour-long seminar just talking about the estate planning documents, the powers of attorneys. And that was one of our first presentations we did, and it was called The Lost Art of Estate Planning. I think that was back in July that we did that. So to the extent that you want a more thorough explanation, check out our YouTube channel, or we also have it posted on our Facebook page as well. And we do have our website up and running too, so you can always find this material on our website. So the financial power of attorney, we always wanted to open and close bank accounts, to sell real estate, defend litigation, make gifts, create a trust. And then specific language that we like to address in our powers of attorneys would be, can we make unlimited gifts? So between spouses, for example, for long-term care planning, can we transfer assets back and forth if we're trying to qualify for Medicaid? Can we create an irrevocable trust if we need it to protect against long-term care costs? There has to be specific language in there if that's what the person wants their agent to be able to do. We need to specifically allow the agent access to digital assets, and then we specifically need to allow them to update beneficiary designations under certain circumstances. So those are very specific things that we like to address with our clients to make sure that all of that's being covered. And so I know I'm going through this quicker than what I want to do. I always want to talk about these documents at great length. So again, if you need some more information, go check out our other presentations. We have the healthcare power of attorney, which is authorizing medical decisions. We like it to have the HIPAA release in there. It's addressing any consents or access to information. It can talk about organ donation and cremation if that's something a client wants as well. The living will would be if you have a terminal diagnosis and you can't express your wishes. We always like to talk about what does that mean, like what circumstances do we want the living will to actually be activated? And sometimes clients have very specific things, if I'm unable to do these certain things, then I want my living will to kick in. So again, it's making sure that the client is comfortable. So typically when we do our initial consultation and we're talking about powers of attorneys, I could probably talk for an hour and a half just on the power of attorney documents and what provisions are important. And so that's why we always encourage clients to bring a copy of a document if they haven't. Any powers of attorneys, I'm happy to look over during that initial consultation, talk about what do you have and what would we recommend that you add or change. Mental health power of attorney. This one is a newer, about 5 years ago, this one came out. And it has a 2-year expiration date. And so we always try to remind clients when their 2 years is expiring. But this is all about allowing consent to experimental treatment, which we explain to clients might be really helpful if there's a drug on the market that's labeled experimental but's making some great headway. So it's all about what do you feel comfortable with and making sure that the document allows for all that you want. And then the last will and testament is just appointing the executor. Where do you want your assets to go? Making sure that we have appointed a guardian or custodian if we're going to have beneficiaries who are under the age. In Pennsylvania, it can be 25 in the will. We want to make sure that we're addressing tax. How's the tax paid? Is it paid out of the residue of the assets? And so we just like to make sure our clients understand all of those different provisions of the will. And then when we have younger clients that have underage kids, we always talk about a standby guardianship form. And that's just a form they can use if they're traveling to like out of town and the kids are staying with somebody, granting them the ability to seek treatment for that weekend or for that specified period of time. We always like to address that. I always like to remind clients that the intestate rules, Pennsylvania will force a distribution of your estate, and sometimes it's not what you want. And so even if you have a surviving spouse, if there are children involved, it doesn't automatically mean your spouse gets everything. So it could be that, your spouse is only getting 30,000 plus half the estate if you don't have a will in place. So again, when we're talking about estate planning, the will is so, so important. So give me 3 steps for estate planning. Again, creating the asset list, updating any beneficiary designations to coordinate with your estate plan. And then finally, that last step would be getting those documents in place and meeting with an attorney to do that. So the next area of law that we want to talk about is asset protection. So give me 3 steps, the first 3 steps for that. So long-term care is what we're talking about with this. This is just because people are living longer, which is great. And so we want to make sure that we're being able to financially provide and pay for that long-term care. So how do we do that? That's really what long-term care planning is about. And asset protection is a way that, especially with husband and wife, you can protect assets to make sure that if one spouse needs care, all of the assets aren't going to pay for care. So give me the first 3 steps. So give me 3 steps. Number 1, those basic estate planning documents. So if you think about it, asset protection is really taking the fundamental estate planning documents and elevating them to the next level. And so we start by making sure that those basic documents, those basic estate planning documents, have certain powers in them. So the reason that we do this is because the most common misconception in Pennsylvania is that your spouse automatically has the authority to act on your behalf. It used to be that's the case, but in Pennsylvania, they no longer assume that spouses like each other enough that the default would be the spouse. So if something should happen, you need to make sure you have a power of attorney in place because otherwise your family has to obtain a guardianship in order to have the right to make these legal decisions. So on average, it takes about 3 months to obtain a guardianship over somebody. And the average cost of a nursing home is about $11,000 per month. So if it takes 3 months, then you're talking about $33,000 of what it would cost to pay for that care. So we want to make sure that a power of attorney allows us to be able to do that. Number two, so give me 3 steps. What's the second thing we want to make sure? So we want to make sure those powers of attorneys have those gifting powers in there, like we talked about, so that you don't have to obtain a guardianship. The second thing we want to do is ensure that your will has a bypass clause in it. So what's a bypass clause? So it's a bypass clause is making sure that if you're leaving everything to your spouse, for example, so if my dad says in his will he's going to leave everything to my mom, what if my mom's in a nursing home at the time of his death? So what you can do is you can say, I leave everything to my spouse unless they're in a nursing home, and then I want it to bypass the spouse. In Pennsylvania, the spouse will always get about 1/3. You can't exclude the spouse completely, but you can have it pay into a trust, and depending on the terms of the trust, that may not be available for the spouse. So again, it's not only about bypassing, but it's making sure that the amount you leave to your spouse can be in a trust and be protected against their long-term care costs if that's what you want to do. But at least you should consider saying that if when you pass away, your spouse is in a nursing home, you're bypassing them and going to the children. So it sounds really simple, but any will that I'm looking at never addresses that. So clients will come in and they'll say, yeah, I have a will. And I look at it and it's about a paragraph long is the language that you need to have in the will, but it's not in there. And it doesn't say, unless my spouse is in a nursing home. So when we're talking about getting those basic foundational documents, it's a power of attorney and then making sure that your will has that bypass clause in it. The second step is determining what assets are available. So this is really important. When I'm doing an initial consultation for asset protection or long-term care planning, the first thing we talk about is what assets are available, what assets can we protect. So a lot of times we'll have clients that have a home, they'll have rental real estate, or they might have like a second home, non-rental real estate. They might have IRAs, life insurance, bank accounts, business interests, any type of collectibles, and then they might have some sort of future inheritance that they're getting. So it's all about looking at those assets and figuring out what would be the available assets and what are exempt, because there are some assets that are exempt. So let's talk about what assets are not available. So a primary residence is not available during life as long as there's an intent to return home. So whenever I'm meeting with clients, I always say, especially for husband and wife, but it could also be for a single person, if that person is being admitted into a facility and they're completing the application for the facility, there's always a question about, is there an intent to return home? And I always recommend that you check that box. No matter how small that chance is, what that does is it makes the primary residence exempt, which means that a nursing home cannot force the sale of the primary residence while the surviving spouse is still alive. So that protects that primary residence. If it's just a single person, same thing. It means the nursing home cannot force the sale of the primary residence while that person is living. Now, again, it's no matter how small that chance is, because what if that person is able to come home and you've sold the house? So I always like to advise clients to go ahead and put that there is an intent to return home. Now, the important thing to know is that the primary residence is only exempt as long as it stays a primary residence. So sometimes we'll have clients who go into the nursing home and then the primary residence is sold. Those sale proceeds are going to be available to pay for their care. It's only exempt as long as it's the primary residence. Second thing to know is that the vehicle of highest value is always exempt. So if they have 3 cars, for example, a nursing home won't look at the vehicle of highest value, but all of the other vehicles can be sold in order to pay for care. The community spouse's retirement. So if we're talking about my mom and dad, if my dad goes into a nursing home, his retirement is available for his care, but my mom's retirement is not available for her care. That is specific to Pennsylvania. If you go into Maryland, they have different rules. So sometimes, because we're right here on the border, a lot of it is discussing, where do you want your spouse to be admitted? We had a client who is actually a Maryland resident, but they were admitting their spouse into a Pennsylvania facility. And what that did, just by admitting them into a Pennsylvania facility, is it then protected that community spouse's retirement, because they chose to have their spouse go into a facility in Pennsylvania. So even knowing those rules, because we're so close to the border here in PA, knowing those rules to help advise clients is really important. The community spouse is also allowed to keep about 130,000 of assets. So again, primary residence exempt, vehicle of highest value, the community spouse's retirement, then the community spouse is allowed to keep about 130,000, and the spouse that's in the nursing home is allowed to keep either 2,400 or 8,000, and that's just depending on income. And then the rest is available to pay for care. That's regardless of whether it's in joint names or in individual names. It doesn't matter. Any other asset is going to be available. So if you have, for example, life insurance with a cash value, that would be available. Even if it's in my mom is the owner. If my dad needs care, it doesn't matter. It's still available for dad's care if the value is more than 1,500, the face value. So it's important that when clients are thinking through asset protection, that, the second thing we do is figure out what assets are available. So usually I compile an asset list and I cross off the things that are exempt. And then I say, okay, this is the amount that we have available. What can we protect of those assets? The other important thing to remember about the primary residence is even though it's exempt, meaning that a nursing home cannot sell it to pay for care, a nursing home can put a Medicaid recovery lien on it. So if we think of the example of my mom and dad, if my dad gets into a nursing home, they can't force a sale as long as my mom's living. But if my dad passes away and he was qualified for Medicaid, they can put a lien on the house, which means when my mom dies, the executor has to satisfy the amount that Medicaid paid, has to pay it back, really. There's a lien on the house. So in order for the house to be able to be distributed, it's probably going to have to be sold, the lien paid off. Okay. So that's why when you're talking about primary residences, it's important to explore all the different ways it can be available. So we want to make sure when we're talking about give me 3 steps for estate planning. The first is those foundational documents. The second is determining what assets are available. And then the third step is considering irrevocable trust. So there are a lot of different ways that you can protect assets. I know that sometimes attorneys will recommend, for example, annuities to help protect against long-term care. And those are all great strategies. What I like to remind clients, though, is if they plan ahead, far enough ahead, that you can actually use irrevocable trust to protect assets. There's a 5-year look-back period in Pennsylvania, but if you do it in like your 60s and transfer an asset, for example, to a trust, the benefit is that after 5 years, that asset is not available. So if it's your primary residence, for example, it makes it so that if you sell it after it's been owned there 5 years, the nursing home can't touch it. So remember, it was only exempt in the primary residence form. If it's not in a trust, as soon as you sell it, it's available. Where if you throw the primary residence in a trust, it's been owned in that trust for 5 years, and then you sell it, the sale proceeds are not available for long-term care. And this is really important when we have situations where husband and wife, husband might be at a skilled level care, and the wife might only need assisted living. And so the wife may need those sale proceeds to buy into a community or a CCRC, a continuing care retirement community, or might need it to pay for assisted living. So these irrevocable trusts are so helpful for our clients. And so I'm going to talk about that a little bit because I also think there's a misconception about irrevocable trusts. Now, the other way that clients can pre-plan, protect in advance would be an investment product. So that's where we're talking about long-term care insurance or like a life insurance with a long-term care rider. And that's why we like to partner with a financial advisor, because that would be a great way to help protect assets. So we always like to recommend with our financial advisor, maybe if you haven't already done it, explore different options for long-term care insurance protection through an investment product. The benefit of that is there's not a 5-year look back period. So as soon as you start paying for that product or for that coverage, you do get the coverage as long as you're paying for it. Let's talk about irrevocable trust, just because I think there's a misconception about how irrevocable trusts work. So let's take my mom and dad, for example. So in Pennsylvania, the way irrevocable trusts work is that my parents can set up an irrevocable trust and they can be the trustees of the trust. So the trustees would be the people who decide how it's being invested, if they're going to sell any assets. They're basically doing everything they did before with the assets that are transferred into trust when it was in their individual name. They have all of that same right, okay? But the only right they can't have in Pennsylvania, if you set up an irrevocable trust and you transfer assets into it, in order to make it so those assets are not available for mom and dad's care, mom and dad cannot have the right to reach into the trust and pull out the assets. Okay, that's the one thing they can't do. So, in a lot of situations, what we're able to do is say, okay, that's all right. We don't need mom and dad to do that. Instead, we might have children, if they're trustworthy, or you might have siblings or a family friend be appointed to be able to reach in and pull assets out of the trust if mom and dad would need to. That's how we're able to use an irrevocable trust. The other important thing to know is that in Pennsylvania, you can have an irrevocable trust and get long-term care protection, meaning those assets are not available to pay for care. And mom and dad can still have the right to change who the beneficiaries are. They can add and remove beneficiaries, and they can add and remove who can reach into the trust for them if they need it. So it really does still give mom and dad a lot of flexibility. So for example, my parents, what I recommended that they do is set up an irrevocable trust, transfer their real estate and some investments that they had into the trust. As long as it's owned by the trust for 5 years, those assets are not available to pay for care. Now, we still leave assets outside of the trust because the goal here is not to hide the assets or make it so the nursing home cannot use some of the assets. But in my mom and dad's case, if something would happen to him and my mom would only be allowed to keep $130,000, my mom would be financially compromised. So by using the trust, what we're doing is we're just isolating or tagging a couple of assets that we think mom would need to use if something happened to my dad to protect that, so mom could live off of that and then use other assets outside of the trust to pay for care. So we don't put all of the assets in the trust. And then what happens is, let's say mom and dad decide they want to sell the house. So remember, my parents are the trustees. They, as the trustee, can sell the house. The sale proceeds are payable to the trust. My mom and dad would open up an investment account, deposit the check, because they're the trustees, in the investment account, and they could invest it however they wanted inside the trust, and it would still be protected against their long-term care costs. If they wanted to have a distribution from the trust, maybe they wanted to go on vacation or they wanted to buy a new car, for example, and they wanted $20,000 of the sale proceeds out of the trust for themselves. What they could do is they could have me as their child, as somebody who they've appointed under the trust document, reach in and pull that money out. And it's not income taxable to me as the person who's pulling it out because it's considered a gift to me for gifting purposes. So as long as I'm not pulling out more than $30,000, so 15 to each of my parents, then I don't have to claim it for income tax purposes. Mom and dad don't have to fill out a gift tax return. It's as if nothing happened for tax purposes. I can reach in and pull out that $20,000 and I can give it to my parents to use to buy the car. If they would ask me to do that and I say no, they can remove me and appoint one of my other siblings. So it does make it really nice. They can even terminate this type of trust if they have the beneficiary sign off. So if I'm the person who can reach into the trust and pull it out, the assets out, if mom and dad would need it, and they decide to terminate it, they would just need me or whoever is the person who can do that sign off on that. So I always like to talk about this type of option for clients because it's really such a powerful tool that I don't know that a lot of clients are aware of. And it's really helpful too for our financial advisors because it allows those assets, those investments to still be invested with that advisor. So it's ensuring that those assets aren't going to have to be liquidated to pay for long-term care. So again, it can still be invested at the financial advisor's office, however the advisor is recommending they be invested. So it's really a great way to help the client protect assets and to ensure that it's being intact and those assets are there for that next generation. So I always like to make sure that our financial advisors know that that is a planning option that they can employ if they have clients that are concerned about long-term care. Now, usually we recommend this if we have clients that have $1 million or less, or have a lot of real estate, but not a lot of cash. So our farmers, for example, these are great tools. These irrevocable trusts are great tools to make sure that we're protecting some, again, not all, we're protecting some of the assets against long-term care costs. And I did do a separate presentation just on the trust with a visual and kind of explained the nuances of that. So you're always welcome to check out, like I said, our YouTube channel and our website if you want more information, or give me a call. I'm happy to talk to you about this as a planning technique. The other thing is we don't want to forget the beneficiary designation. So just like for the will, we want to say, well, if the spouse is in a nursing home, we want it to bypass the spouse and go to the children or whoever would be receiving under the will. We use that same concept with the trusts. So we don't ever recommend transferring retirement accounts into the trust because it triggers all the deferred taxation that a client has had. But what we might do is we might recommend that they designate the trust as the primary beneficiary. That's because my dad's case, for example, let's say he dies and at the time of his death, my mom's in a nursing home. If it pays all to my mom, it all goes to the nursing home. But if they're using a trust to protect real estate or other assets, we may say, okay, we're not going to transfer the retirement during my dad's life into the trust, but we're going to designate the trust as the primary beneficiary of the retirement account, and we're going to name my mom as the contingent beneficiary. So then when my dad dies, if my mom's in a nursing home, it doesn't all go to the nursing home or it doesn't kick my mom off whatever benefits, it would go into the trust. If my mom is not in a nursing home, remember, she's the trustee of that trust. So she can disclaim, which just means she can say, I don't want it to come into the trust, and then it would pay to her outright as the contingent beneficiary. So then she would have the option to roll it over and do all of the benefits that you have as a spouse tax-wise. So that way we can make sure we're covering the situation where if the spouse is in a nursing home, we're protecting those funds. If not, we can have the spouse as the contingent beneficiary. So it's a post-mortem planning technique that we can use if we need to do that. So that's why I put, don't forget the beneficiary designations. Okay. So the give me 3 steps for the asset protection planning was making sure you have those basic foundational documents in place, the powers of attorneys, the wills with a bypass clause in it. Second thing was determining what assets are available. And then the third thing was considering protection techniques, one of which would be a trust. And again, it could be a trust, it could be an investment product, it could be an annuity, it could be loans to the kids. All of those are different options. So make sure that you are talking to an attorney that is aware of all those different options so that they can talk through that and share all of that with the client. So let's move on to business planning. So let's talk about give me 3 steps for business planning. So how do we handle this? So first is organize it properly. So the way to do that is consider an entity or, and this is a less popular option, and I think that's just because attorneys aren't as comfortable unless they deal with trusts. We deal with trusts all the time. You can also consider using a trust. So we have, for example, a lot of family farms that we are happy, we love doing that type of planning. And instead of transferring it into an LLC where there's going to be realty transfer tax to redeed the property into the LLC, we can transfer it into the trust and there's no realty transfer tax to transfer it into the trust depending on who the beneficiaries are. So you can get even more protection in the trust and not have to pay the transfer tax. So an entity protects to some degree, but a trust is going to protect against any creditors as well as any long-term care, any nursing home costs. So that's why I think a trust is an even better option. I just don't think people are aware that that is an option. And it's not, we don't use a trust for all of our businesses because if it's like, for example, a law office, a medical practice, if it's a computer store, something like that, we wouldn't probably use a trust. But we have a lot of farmers in this area that we represent. And so a trust is a great option for them. Or an entity. So we can do like an LLC or a partnership. That would be another great way to help protect assets. So it's just considering what entity, what gets you the biggest bang for your buck. So when you're using an entity, it will lower the value for gifting purposes, and it also offers creditor protection. With a trust, it's not subject to realty transfer tax, and it offers that same creditor protection. And a trust really can be operated the same way as a business entity, so this is another great option. We've actually had instances where a client has an LLC interest, and they take that LLC interest and assign it to the trust. And the reason they might do that is to protect the entity, the LLC interest against their long-term care costs. And that's really important where you have 2 or 3 or multiple partners, and one partner might be sick or have a diagnosis or might be, age 65 or older, and we're just trying to think through planning and protection. You can take that LLC interest and assign it into a trust, and that then protects that business entity, that business interest from long-term care costs. So again, sometimes even when we have an entity, we still consider a trust. We also like to recommend, you can do gifts through your last will and testament, you can do pattern gifting of the LLC or FLP, and then you can do some buy-sell agreements. So it's all about making sure you select the correct entity or the correct formation for you when we're talking about protecting assets and really maximizing the options legally that you might have. Give me 3 steps. Step number 2 is proper formation. So when we have an entity, this one is really specific to an entity, but a trust could come in. We just don't see a lot of practitioners in this area recommending trust, which I do think is a shame because sometimes trust would be more advantageous for a client. But we have a lot of people who come in with an entity, an LLC, or a partnership already in existence, and it's not properly formed. So what we do is the first thing we do is get on the Department of State website and look up the entity and say, okay, was it registered? And that's registering with the Pennsylvania Department of State. So it secures the names that nobody else can take that name. And it also is that first layer of protection for from creditors, because you have to have it registered. There has to be an office. That can't be a PO box that creditors can contact that entity if they need to. So when we're looking at creditor protection for an entity, one of the ways that we ensure that is to make sure it's properly set up. Then obtaining an EIN if that's needed, if there's going to be a bank account or a separate tax return. Executing the governing documents. So if you have an LLC, that would be an operating agreement. If you have a partnership, it would be a partnership agreement. Or if it's a corporation or an S corporation, it's bylaws. So it's making sure you're registered, if not registering, getting an EIN if you need to, executing those basic documents, the governing documents, changing the officers with the Department of Revenue. So often we have situations where a business owner comes in and it might be registered with the Department of State, but we look on the Department of State website and we see that the last time that had been updated was 1995, and it's somebody who no longer owes the business who's listed as an officer on the Department of State website. So we have to update that with the Department of Revenue. So, and then holding annual meetings. It's going to sound silly, but I have so often met with business owners that say, nobody has ever told me to do this. And it's just making sure you have it properly registered and all of the documentation you need. And we can do that in the initial consultation with our computer. We just get on the Department of State website and look it up, make sure it's registered properly, confirm the address, confirm the officers. And then we help a client if they are going to register a new name, how to do that. We can file that online so it doesn't take as much time, which is important right now with how slow things have been with the shutdown that we were dealing with. So when you're talking about a business entity, it's choosing the correct entity, whether it be a trust or a business entity, then making sure that it's properly set up. And if it's a trust, making sure that the trust document addresses it. So this is just, we always do a visual that shows what does the trust say, how are assets distributed. And then give me 3 steps. The third step is the addressing estate planning concerns. So when you have a business, and let's just say you have a partnership, and it's 2 brothers, we want to make sure, think about this. So often the financial power of attorney that a client has doesn't distinguish the difference between business and personal finances. So if you have a business partner and you become incapacitated, you may want your other partner to be able to handle anything related financially to the business and not your spouse and not your child. And so we either do 2 separate financial power of attorneys, one for the business and one for personal, or if we just want to do one, we can in the document specify that for Any business, we actually have a paragraph in there that deals with business activities. Those activities are designated to this specific individual. So often we have estate planning documents that need to address if somebody's incapacitated, what happens? And in the will, it needs to address where does the entity go at death? And you need to think through the inheritance tax implications of that. Is it subject to inheritance tax? Does it meet the exemption as a business or as a family farm? So making sure you have a bequest in the will. Is there a buy-sell agreement? Is it in the governing document? Is there life insurance that's funding that? So the give me 3 steps for the business planning start with making sure you have the proper entity, whether it be a business or a trust. The second one is to make sure you have it properly formed once you decide. And then the third is bringing that and kind of integrating it with your estate planning. Those would be the first 3 steps. I know that there were kind of sub steps under that, but those are the 3 big first things you need to do with an entity. Okay, so now we're on our last one. This is estate administration. So we kind of did what all you can do during life, and then estate administration is obviously when you pass away, making sure your estate is distributed and administered the way you want. So let's talk about, give me 3 steps for estate administration. So the first one, the estate administration was hard for me to just give 3 first steps. So this is my best attempt. So number 1 would be determining if probate is needed and then appointing the personal representative. Now I know that that's actually 2 things in one, but there are some times where probate's not needed, where you still have to have a personal rep who's going to be handling the administration. And a lot of times we have clients who are kind of panicked about what is the first step I need to do in order to administer the estate. So we'll get a call, and usually it's after somebody passed away and it's letting us know this individual has passed away. What do we do? So it's determining if probate is needed. Now, please know that the funeral home will do the death certificates. So we always recommend that you get a death certificate per financial institution where assets are held that was in the decedent's name. So for example, if they had something at Vanguard, Fidelity, and BB&T, we would say, okay, then you're going to need at least 3 death certificates because each of those entities is going to require one, and you can get that through the funeral home. Now, they are more expensive. They used to be more cost efficient, but I think now they're $20 per death certificate. And I think it's for the first 90 days you can get them through the funeral home. Otherwise, you have to order them through Pennsylvania, through the state. So we always like to remind clients when they call in, and usually that's the first call we get, how many death certificates do we need? We're happy to contact the funeral home and say, this is how many death certificates we think we're going to need. So I wanted to address that first, but then we have to say, well, is probate needed? So the probate's the process by which you take something that's in the decedent's name, the person who died, and you get it to the new owner, okay, through the will or through the beneficiary designation. Probate is the process when we have to do it through the will that gets it from the person who died, from their name, to the beneficiaries in the will. Probate is the process by which you do that. If you don't have a will when you pass away, then Pennsylvania is going to implement their estate plan for your assets. So when you figure out, so when you determine that probate is needed, so a couple of things there, if it's a joint ownership, if it's a beneficiary designation, you're not going to need to probate. But if it's in the individual's name, you're going to need to probate. And if it's a bank account that was in the individual's name that exceeds $10,000, you're going to have to probate. So that's one way to determine. So these are all different ways to do it. I know we're running out of time, so I'm trying to consolidate some of these thoughts. But please know, I think we did 2 separate seminars on the estate administration process that we have posted on our YouTube channel. So if you want more detail, you can go check that out. But just knowing when you need to probate is really important. And that's what we do during our initial consultation when someone passes away and we're having the family members come in and talk about it. It's determining whether or not we need to probate. That's the first thing we're doing. So we're asking, what assets did they have? How were they titled? What was the amount? And so sometimes clients will ask why we need all of that information. Here at our office, we need that information because we're trying to determine if probate is needed. Okay, so what would be subject to probate? No beneficiary designation, no joint owner, and no transfer on death or pay on death designation. And Again, if it's in a trust, it's not subject to probate either. So that's almost like it's been tagged with a beneficiary designation. If it doesn't fall into one of those categories, then you will have to probate in PA. So ways to avoid, tricks to avoid probate would be beneficiary designations, which we talked about, making sure that all marital assets are jointly owned. And then if there's bank accounts, things like that, again, it depends on the amount. So if it's in an individual's name, but it's less than 10,000, we don't have to probate that, okay? So the second step, so the first step was, do we need to probate? And so again, we do that free initial consultation to determine, do we need to probate? And that's where we're doing some asset collection, trying to figure that out. Second step would be, in our Give Me 3 steps, would be sending the appropriate notices. So if we have to probate, notices have to go to the beneficiaries. We also have to advertise the estate. And so that's when we're talking about notices, we're talking about notices to the beneficiaries, advertisements, and it has to be in a legal journal and a paper of general circulation, and you have to do that for 3 weeks, okay? So those notices are required. If you have a trust, you still have the notice requirement and the advertisement requirement depending on the type of trust. We also like to notify the Department of Public Welfare, which is actually Department of Human Services now, DHS. You have to do that if the person was over 55 and receiving medical assistance. But if they were over 55, we always notify them, because if we're representing the personal representative, the executor, we have to ensure that there's no lien there that the Department of Human Services would have. So we always notify DHS if we have anyone over the age of 55. Okay, so first step was determining if probate is needed, and then if so, appointing that personal representative. Please know that in Pennsylvania right now, we do have virtual probates. We're able to do it virtually as long as there's an attorney involved. The second step was the notice requirement. So we send it to the beneficiaries. We send advertisements to a legal journal and paper of general circulation. We also send it to the DHS, Department of Human Services. We additionally send it to the Pennsylvania Department of Motor Vehicles, DMV. And then we send a notice to the 3 credit reporting agencies too. So those are additional things that we like to do. And that's just to make sure that the executor is doing everything that they need to, okay? Second step was making sure that the filing forms are by the due date, which I actually think this is the third step. So I'm sorry about that. When we're talking about our Give Me 3 steps, it's the third one. It's the filing forms. So what needs to be filed? So if there's real estate, and inventory needs to be filed. And even if there's not real estate, we still do an inventory in our office. We just don't file it with the court. We keep it here so that if the beneficiaries would ever need that inventory, we have it. And so that's what the executor or the administrator is going to create, is that inventory. And so we do that for our executors. And then the big thing is the Pennsylvania inheritance tax return, which is the Rev 1500. So in Pennsylvania, if something is transferring because somebody died, then there's going to be Pennsylvania inheritance tax. So the tax return has to be filed disclosing the date of death value for those assets. So the Rev 1500 is due within 9 months of the date of death. However, if you pay the tax, they call that prepayment, within 3 months of the date of death, you do get a 5% discount on the tax that is owed. Okay, so our office is always trying to save money, pay the least amount of tax. So what we'll do is, even though we might not file the return until 9 months, we always like to prepay the tax by the 3-month deadline to the extent we're able, so that we can get a 5% discount. Just because we're able to avoid probate doesn't mean we're avoiding inheritance tax. So just know that you might not have to go through probate, but the inheritance tax return may still need to be filed, and there may be tax that's due. You're going to always file a Pennsylvania inheritance tax return if there's a retirement account, and that's even if the surviving spouse is the sole beneficiary. By law, you're still supposed to file that Pennsylvania inheritance tax return. Now, what you're doing is you're filing it, saying what the date of death value is, and there's actually no tax for a spouse, but you're required to file it. And these are all things that are subject to inheritance tax. So I'll leave this, as we go through, I'll leave this up here for a second, but know that the only thing that is not subject to inheritance tax is life insurance death benefit proceeds, and any exemptions, like there's an exemption for family farms and for family businesses if you meet certain requirements. Everything else is going to be subject to that, including gifts that were made within a year of death. Okay, to the extent they exceed $3,000 in that calendar year, then there's going to be inheritance tax on that. And then a trust, there might be, depending on what the trust says and what the decedent, the person who died, what they retained in the trust. And then these are the tax rates. So we have certain things that are exempt, like charitable organizations. The spouse, interestingly, they're not exempt, they're just taxed at a zero rate. And that's because at some point they were taxed previously. Just now, under the current law, they're not. So they're subject to tax, it's just at a 0% rate. And then anyone in your line, either up or down, so whether it be parents on up or whether it be children and grandchildren, they're taxed at 4.5%. That's direct lineal descendants or ancestors. Siblings are taxed at 12%, and then all other beneficiaries are taxed at 15%. And then, okay, I'm sorry, it was our third step. So distribution to beneficiaries, when we're talking about give me 3 steps, then we distribute it to the beneficiaries. So it may take a while to do that depending on the administration. What we try to do here at our office is do it as efficiently as possible. And I can tell you that, we're able to most of the time close estates within a year. And that's always our goal, is to do it as efficiently as we can. And the way you do that is either you have to do it the formal way with the formal accounting, or you can do it with a release signed by all the beneficiaries. So that's at risk of personal representative. That's the first option. And I would say that 80% of our estates are under the all the beneficiaries sign off and we distribute it, and we don't actually have to file something in court. This talks about how you file the accounting. And again, I'm just going to breeze through this because we do have a whole seminar just devoted to this. You have to file the accounting, and this talks about how you file it and who has to receive notice of it. This talks about when you're making a distribution, you have a receipt and release, and all the beneficiaries sign off on that, and then nothing has to be filed in order for assets to be distributed. Our next monthly seminar is June 21st. We're doing them virtually. We aren't holding them in person, just like we're able to do client appointments to the extent the client wants to. We're always happy to do phone or virtual appointments as well. So our next seminar is June 21st, and it's Adventures in Medicare. So my dad is turning 65 this year, and so one Sunday we sat down and attempted to apply for Medicare. So I wanted to walk you through that and just what our experience was and the pros and the cons of that. So that's our next month seminar, just in time for Father's Day. You can register by emailing Amy Meek here at our office at meek@skwlawoffice.com or by calling at 717-655-2676. We also, now that we have our website up, we do have a registration form on our website. And like I said, once we're done today, we record it and we will post it on our YouTube, Facebook, and we do then put it on our website. And then we will be sending an email link, just survey for feedback. So we're always welcoming the feedback. That's actually how we decided to do this next seminar, the one that we did today. So we always appreciate that. So what I'm going to do now is thank you so much for joining us today over lunch. The other thing I will tell you is we're working on our next newsletter. That's probably going to go out by the end of May. So to the extent that you're not receiving them, we always try to send them out in cards to our clients. So if you haven't received them, or if you're not a client or a referral source, we always are happy to send that to you. So you can always reach out to us and we can send you even past issues. So we try to do them quarterly with information for our clients. So that being said, I am going to turn off the recording and I'm happy to take any questions. Thank you so much for joining us today.
Good job, Samantha. Just a couple of questions.